Before we even step into this virtual courtroom, let's break down what's about to unfold, because this isn't your typical custody dispute. This is a dependency case, and that changes everything. We're not here to determine guilt. We're here to determine whether a child identified as ZH is legally without proper care and custody. And what makes this case especially intense? The parents themselves are admitting they cannot take their child home. Now pause on that for a second. On September 15th, during a team decision meeting, these parents expressed they were unable or unwilling to pick ZH up from the emergency department, citing violent behavior toward them and other children in the home. That is a huge statement in a courtroom. When parents acknowledge they cannot safely parent their own child, the court shifts into protection mode fast. We've got Assistant Prosecutor Laura Clifton, attorneys for both parents, a child's attorney, agency workers, and a caseworker from Wellspring ready to testify about residential placement. The judge's role? Determine whether statutory grounds exist to take jurisdiction over this child and decide what happens next. But here's the twist: while the parents say ZH has been violent and out of control, once placed in residential care, reports suggest she's actually doing fairly well. So what's really going on here? Is this a case of a child in crisis who needs structured treatment, or a family that reached a breaking point? And how does the law balance parental rights with a child's safety when no one is technically a respondent? Stay with me, because the legal nuances here are subtle, the emotional stakes are high, and the judge's decisions in the next few minutes will shape this child's life for at least the next 9 months.
This is the matter of ZH, case number 25-51495NA. Present in the virtual courtroom, we have Assistant Prosecuting Attorney Laura Clifton. We have Mother Abigail Hilgendorf. We have Mother's attorney, Mr. Sherlin, and attorneys, I should say, Mr. Sherlin and Ms. Preston. We have Father Ian Hilgendorf. Who is also represented by Mr. Sherlin and Ms. Preston. We have the child's attorney, Charlie Clapp, various agency workers. All right, we are here for an adjudication in this matter. And Ms. Clifton, my understanding is parents are not respondents. This is a dependency case. We simply need to establish a factual basis for the dependency petition and the grounds under the statute. And for that purpose, we will be asking the parents to admit to paragraphs A, B, L, and M of the petition. Is that correct?
That is right.
Okay. Mr. and Mrs. Hilgendorf, if you would unmute, please. Great, thank you. Would you both raise your right hands, please? Do you swear or affirm the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth?
Yes.
I do.
All right, thank you. And are the parties willing to waive the reading of the petitions?
So waived,
Petition.
Your Honor.
Yes,
Yes,
Your
Your
Honor.
Honor.
All right, thank you. All right. Paragraph A reads, Ms. Abigail Hilgendorf is the legal mother of ZH per Kent County file number 1927356 AM. Is that true, ma'am?
Yes.
Sir?
Yes, it is, Your Honor.
I'm sorry, sir, did you say yes as well?
It is true, yes.
Okay, thank you. Paragraph B reads, Mr. Ian Hilgendorf is the legal father of ZH per Kent County file number 1927356 AM.
That is
Is
true.
that correct? Okay,
Yes.
all right. Paragraph L reads, on September 15th, 2025, a team decision meeting was held. Mr. and Mrs. Hilgendorf expressed they are unable and unwilling to pick ZH up from the emergency department due to ZH being violent towards them as well as their other children. They do not have a successor guardian or family member who is able to provide care for ZH.
Yes, that is true.
That is true.
All right. And paragraph M reads, ZH is without proper care and custody.
Yes.
Yes.
Let's pause right here, because this moment is legally significant. When both parents confirm that ZH is without proper care and custody, they are establishing the factual foundation the court needs to step in. In dependency cases, the court doesn't require a full-blown trial if the parents admit the allegations. Those admissions, paragraphs A, B, L, and M, are enough to trigger jurisdiction under the statute. But here's what stands out. This isn't about abuse allegations in the traditional sense. The central issue is behavioral instability violence, repeated runaway incidents, and being beyond parental control. That's why the judge references substantial physical or psychological harm. So legally speaking, the court isn't punishing the parents. It's declaring that the child's circumstances meet the statutory definition of dependency. And here's the question I want to throw to you. If you were in the parent's position fearing for your safety and the safety of your other children, would you make the same admission? Or would you fight jurisdiction and risk prolonging instability? Because once the court takes jurisdiction, the state steps in, and that changes the entire power dynamic moving forward.
All right, thank you. Anything further regarding a factual basis from you, Ms. Clifton?
No, Your Honor.
Mr. Sherlin?
No, Your Honor.
Ms. Preston?
No, Your Honor. Sorry.
It's all right. Mr. Clapp?
No, Your Honor.
Right, the court finds that there are statutory grounds for the court to take jurisdiction in this matter, specifically that this juvenile is in danger of substantial physical or psychological harm and is dependent because the juvenile has repeatedly run away from home and is beyond the control of a parent or other legally responsible person. So the court will take jurisdiction. And are we prepared to go on to dispositions at this time?
Yeah, I think we can do a short disposition. I think I have 3 exhibits, and I would call Ms. Saunders when the court's ready.
All right, Ms. Saunders, would you raise your right hand? Would you state your name and spell it for the record?
Katie Saunders, Katiesauндers.
And do you swear or affirm the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Your Honor, the 3 proposed exhibits are the CPS report with a cover sheet dated 10/23/2025. I have Ms. Saunders from Wellsprings Case Service Plan Parent Agency Agreement, which is dated October 15, 2025. And then I have a court addendum from Ms. Saunders, which is dated 11/3/25. And I guess I have Exhibit 4, which is a Maximus Specialized Placement Division dated October 30th. So that would be Exhibit 4.
Okay, I don't have the addendum or the Maximus report. Ms. Gibson, do you have that?
I'm looking for a hard copy in the social file. I don't see it.
I can wait for the next hearing, Your Honor.
Wait, I do have a hard copy of the addendum, but I don't see the Maximus.
How about then we just do the hard copy of the addendum?
All right.
Oh, it's attached to the
Yeah.
addendum, so I will
that's how
go
mine
scan it
was
right now,
too.
so we have both of them.
Okay.
All right. Thank you. Any objection to the admission of those exhibits?
No, Your Honor.
No, Your Honor.
No,
All
Your
right.
Honor.
Okay, they're admitted.
Thank you, Your Honor. Ms. Saunders, you're a caseworker for Wellspring, is that correct?
For this specific case, yes, my title is Division Director, but I'm holding ZH's case currently, yes.
But you are supervising ZH's case?
I'm the current caseworker on this case, correct?
Okay, good. And she has been, much to your hard work in the last few weeks, she has been placed in a residential placement, correct?
That is correct.
Why don't you explain to the court where she is and how it is going so far?
So currently, ZH is placed at Whaley's Children's Center, and since she was placed there on October 29th, she has done fairly well. Educationally, there have been some bumps as far as being able to concentrate in the classroom, being able to get along with some peers in the classroom. So we are evaluating, looking at schools outside of the residential, potentially if they would be a better fit for ZH. She does have a current IEP that was just revamped about 2 weeks ago when she was in shelter care. And so we will be utilizing that. And again, the current residential is looking at classroom size and just ensuring that she is getting what she needs in school. But as far as the residential and her placement there, she has done really well. There have been no issues reported as far as her acting out behaviorally. There's been a few situations where she's gotten frustrated and she's had to be de-escalated, but nothing that the staff have not been able to handle. But as far as the, reports and historically of her being physically aggressive or getting to a point of being unsafe, she has not exhibited those behaviors since.
Okay, this is where things get interesting. We just heard that since being placed at Willie's Children's Center on October 29th, ZH has not exhibited the physically aggressive or unsafe behaviors that were previously reported. There have been moments of frustration, yes, but nothing staff couldn't manage. That raises a powerful dynamic. Sometimes structure, therapy, and a controlled environment can stabilize behaviors that spiral at home. But it also makes you wonder, was the issue purely environmental? Was it family dynamics? School stressors? Mental health support gaps? We know she has an IEP that was recently revamped, and educational challenges are still being evaluated. Legally, this actually strengthens the case for continued residential placement. Why? Because the agency can now argue the child is responding positively to structured treatment, and courts are very reluctant to disrupt a placement that's showing improvement. But emotionally, there's another layer. ZH lights up when she talks about her family. She misses them. The parents are engaged, calling daily, attending visits. So here's the tension. If she's thriving in residential care but deeply attached to her family, what's the long-term plan? Reintegration? Extended treatment? Something else? Drop your thoughts below. Do you think 9 months is appropriate, too long, or not long enough?
Being in care.
Excellent. And what is the time she's going to be there, if if that's possible to say?
Yeah, at this point, we're looking at least 9 months of treatment at Whaley.
Okay. And we can address future of that later. And what is the what is this residential plan replacement, what's in it? It's school, it's treatment, what else is in it?
Yeah, she has provided, specialized care in her school. She's given multiple times a week. She has group therapy with the other individuals in her home. She will have individual therapy. She will have the ability to do specific things in the community to help her regain the ability to be safe in community settings. The home that she is currently placed in is actually in a community. They do have a main campus, but the home is specifically in a community. So that helps her being able to transition with ensuring that she's able to be safe and, deal with the day-to-days that happen out there. She's able to be involved in extracurricular activities, whether that's sports or different things that are going on through the residential, and continue with parenting times with her family members as well.
Before we get into parenting time, where is this placement located?
It's in Flint.
In Flint, okay. And my understanding is Mr. and Mrs. H have been involved through telephone, Zoom, or some kind of contact with ZH?
Yes, they've had lots of involvement with the ZH. I think they speak to her on the phone almost every single day.
Excellent.
And then they also have scheduled virtual parenting times once a week. And just last week, we're able to do an in-person visit with her at the residential as well.
And all that is going well, I take it.
It's all going well. ZH seems very happy. She always lights up when she talks about her family, because I know that's one thing that she has stated that she continuously misses. She seems to engage well for the most part during those parenting times. And I know this in-person one this past week seemed to go well, which what was reported to me.
So her parents are very engaged.
They are, yes.
You don't have any concerns about that at all?
I do not, no.
Okay, all right. What are your is she having contact with anyone else?
She does have contact with her biological mother, who was doing weekly virtual visits as well. over the last week or so, contact has decreased a bit, but she is in contact with her mother, and she calls her every once in a while as well.
Okay. Any concerns about any of those contacts?
Not at this time.
Okay. What are your recommendations at this time?
Yes, I am recommending that ZH remain a temporary court ward of the court, ZH be placed in a residential facility, that the parenting time of Mr. and Mrs. Hildendorf be at the discretion of the agency, that the parenting time of Miss Anisha Nixon be at the discretion of the agency, all parties comply and benefit from the parent agency treatment plan, and that this matter be reviewed in 90 days.
Thank you. I don't have any other questions, Your Honor.
Thank you. Ms. Clifton,
No questions, Your Honor.
Mr. Sherlin,
No questions, Your Honor. Thank you.
Ms. Preston.
No, Your Honor.
All right. Thank you. Any further witnesses, Mr. Clapp?
No, Your Honor.
All right. Any witnesses, Ms. Clifton?
No.
Mr. Sherlin?
None, Your Honor.
Ms. Preston?
None, Your Honor.
All right, I just have a question about the order. Since the parents are not respondents, typically the court would not enter an order for parenting time since they're entitled to time whenever it can be arranged. Is that something that the agency or the facility needs?
In speaking with the facility, if it is not in the order, that is fine. It's based off my recommendation.
Okay. As like I said, they're not respondents in this case, so I don't see the need for an order, but I also know some of these places have needs that sometimes it's just easier, but
Yes.
and then the same thing with Ms. Nixon. Do we need an order for her?
Again, that would be based off my recommendations. The facility is fine with that.
Okay, so no need for that order either.
Correct.
Okay.
This exchange might seem procedural, but it's actually very telling. The judge clarifies that the parents are not respondents in this case. That means they haven't been accused of wrongdoing. So typically, the court doesn't need to order parenting time. They're entitled to it unless restricted for safety reasons. That's important. It signals that the court does not view the parents as the problem here. The focus remains squarely on ZH's behavioral and psychological needs. The agency's recommendation that parenting time be at the discretion of the agency is standard language. But the judge is careful not to overstep by imposing unnecessary restrictions. That balance, protecting the child while respecting parental rights, is at the heart of dependency law. And notice something else. No objections. No cross-examinations. Every party concurs with the recommendations. When prosecution, defense, child's attorney, and agency all align, that usually means everyone agrees this placement is currently in the child's best interest. But consensus doesn't always mean simplicity. These are layered decisions with long-term consequences.
Any follow-up, Ms. Clifton?
No, Your Honor.
Mr. Clapp?
No, Your Honor.
Mr. Sherlin?
No, thank you, Your Honor.
Ms. Preston?
No, Your Honor.
All right, thank you. Statements? Ms. Clifton?
Your Honor, I would ask that you accept the recommendations.
All right, Mr. Clapp?
I would concur, Your Honor.
Mr. Sherlin?
Your Honor, on behalf of Mr. and Mrs. H, we would ask the court to adopt the recommendation.
Ms. Preston?
I concur with Mr. Sherland.
All right, thank you. The court finds that the lawyer guardian ad litem has complied with the requirements of the statute, so long as the court receives confirmation that that has happened in the next couple of weeks. That an order enter placing this child in the temporary custody of this court and placing with the Department for Care and Supervision. Sorry, I'm looking for the institutional placement language. All right. I will continue the attorneys in this matter. And Ms. Gibson, do we have a date for our next review hearing?
Yes, Your Honor, February 4 at 10 a.m.
Any conflicts with that date or time?
No, Your Honor.
No, Your Honor.
Okay. Mr. Sherlin, are you, looking, you're muted.
I'll be out of town, Your Honor, but Ms. Preston can cover.
So here's where this case stands. The court has formally taken jurisdiction over ZH, finding statutory grounds based on the admissions that she was without proper care and custody and at risk of substantial harm due to repeated runaway behavior and being beyond parental control. She will remain in residential placement at Willie's Children's Center in Flint for an anticipated minimum of 9 months. The department now has care and supervision authority, and the case will be reviewed again in 90 days. Parenting time remains ongoing without restrictive court orders, reflecting that the parents are not respondents and remain actively engaged in their child's life. Legally, this was a clean proceeding, clear admissions, aligned recommendations, structured treatment plan. But emotionally, this is a family navigating crisis under court supervision. The broader implication here is powerful. Dependency court isn't always about punishment. It's often about stabilization and rehabilitation. The system stepped in not to sever bonds, but to create safety and structure where the family couldn't do it alone. Now, I want to hear from you. Do you think residential treatment is the right move in cases like this? Should courts intervene sooner in behavioral crises or later? If you found this case as intense and thought-provoking as we did, make sure to hit that like button. Share your thoughts in the comments. And don't forget to subscribe for more jaw-dropping courtroom breakdowns.